Welcome to Self-Represented in Family Court. Your host, Tracey Bee. That's me. So, here we discuss strategies. Yes, strategies and how to use them to get the results you want in family court. If you're self-represented, pro se, pro per, or if you have an attorney and you just need to know what it takes to get through this complex family court system we have, this is the place to be. We discuss strategy. We discuss tactics. We discuss tips and tricks. We discuss techniques. We discuss secrets. We discuss it all. Whatever it takes to get you the strategy that you need, that's it. That's here. That's what we do. So sit back, take notes, and kick ass. Well, hello there. It's me, Tracey Bee, the family court strategist, pro se advocate, and the owner of the Divorce Solutionist. And you're listening to Self-Represented in Family Court. Well, as promised, I am going to continue our discussions on domestic violence related topics in honor of Domestic Violence Awareness Month, October. Yes. So I wanted to talk about something that has been a really widespread and talked about topic, at least amongst my audience, and that is coercive control. Coercive control is actually another form of domestic abuse, or IPV. The reason I want to actually spend some time to talk about it is because I remember I think it was last summer or the summer before last. I don't recall. But I remember my particular audience, a few members of my group specifically, begged me to do an actual live on the topic because I believe it was the state of Pennsylvania had just recently passed Caden's Law. And there were people who were really, really hopeful about the impact that it would have on their cases that were pending, or that cases that were actually not pending, but they had cases or they had issues that they felt met the criteria to actually go to court and get some sort of justice. And I remember actually talking to a few people and explaining to them that the impact of coercive control in family court is nothing, I hate to say it, but I have not changed my position. It's nothing the way most people had imagined it. And that has not changed. So let me back up a bit. Let's talk about what coercive control is. Coercive control is a pattern of behaviors that that's used to manipulate, control another person's freedom to move, to behave, to act, to speak. So it's not necessarily physical abuse, or it's not necessarily any sort of physical manipulation or control where they're actually physically restraining the person, but they're doing things like controlling spending, controlling who they can spend time with, controlling the amount of time they spend on the phone, controlling when they get home from work, how long it should take them to get home from work or from, mom's house, or they're just really controlling and manipulative when it comes to actually imposing or restricting the freedom of another person to make their own decisions and their own choices. Now, to me, it's actually another form of mental, psychological, and emotional abuse. I believe the founder, or the person who actually made this term popular or notable, was Dr. Evan Stark, a sociologist and a forensic social worker, who coined the term in his book, Coercive Control: How Men Entrap Women in Personal Life. At that time, of course, it was, let's be honest, we still live in a patriarchal society. And so, you know, a lot of times it was, back then, I mean, to some degree now, but back then, the manipulation and control was much more available, shall I say, for men to do that with women, because they were in a position of power, financial power, or they were in a position to have some sort of ability or resources to actually control. And it's usually who they control was the woman who had less than. Um, Not that the scales was so unbalanced in 2007. We're talking about 17 years ago. And, you know, 17 years ago, women were, you know, still, you know, CEOs and heading organizations and, you know, being the breadwinner, while dads were actually becoming more of the stay-at-home parent. But we're still in a patriarchal society where women still don't even get equal pay as men. So, you know, that just, I'm saying this because I want to bring home the point as to why in 2007, Dr. Stark, I'm assuming, thought to name the book How Men Entrap Women in Personal Life, because women entrap men too. When I'm talking about coercive control, I'm not, it's gender neutral. I am not advocating that it happens more with men as opposed to women or vice versa. But I'm trying to explain anyway, the best that I can. I didn't read the book, in all transparency. I didn't read the book. I plan to. It's just that I have a long list of books that I need to get to, in addition to all the other things that I juggle throughout my day. So, and I'm not a fan of audiobooks. I know that's what a lot of people say. For some reason, I need to read the book. I need to actually hold the physical book in my hand when I'm reading it. I know I'm still very, very, very old-fashioned when it comes to things, certain things. And so, anyway, so in 2007, when Dr. Stark coined that term, he defined it as isolating a victim from friends, depriving a victim of basic necessities, controlling or monitoring their movements, communications, daily behaviors, emotional abuse, psychological manipulation, and economic control. So, I know the question you're asking is, well, financial abuse and emotional abuse and psychological abuse were already things that existed. Why was there a need for coercive control? Well, I don't know that Dr. Stark intended to actually get this agenda to be something that is taken up by the criminal law or the criminal bar or the criminal component of domestic violence organizations and advocates, but that's pretty much why it's distinguished from mental, emotional, and financial control and abuse, because no state that I found, anyway, after doing my research, has anything on the books that makes it a crime to commit emotional abuse, psychological abuse, or financial abuse. Financial abuse, it may be a little different because there are instances where financial abuse are considered crimes, but that is way beyond the scope of this week's discussion. So I'm not going to spend too much time on that. But situations where there's like elder abuse or agent, principal abuse, fiduciary abuse, things like that. That might fall under the umbrella of financial abuse. But again, that's another topic for another day. But coercive control happens to be something that didn't necessarily specify emotional or psychological abuse or even financial abuse, but it was actually, it broadened the scope. And what it did was it allowed states to actually include that in their DV laws. And when I say their DV laws, I mean it actually encouraged states to make it a crime for anyone who abused or manipulated or controlled another using those tactics. If proven, of course. Everything is proven. So right now, I believe there are about 10 states that actually do have coercive control laws on its books, where they actually consider it a crime under domestic violence laws. Um, and those states pretty much, they vary in the extent of who they apply to, the statute of limitations, how they define it. But for the most part, they all have included, for simpler terms, emotional abuse as a crime. Yeah, as a crime. Why is that important for us, right? Why is that important for us in family court? Well, in every single state in this country, there is what's called the best interest of the child factors that the courts must consider when it comes to deciding custody. And you should all know what that is by now, because if you've been following me or listening to me, you know that I talk about the best interest of the child factors often. The BIOTC is what I usually refer to them as. And most courts actually have as one of their factors the presence of abuse. That is one factor that the courts will consider when they're deciding custody and or visitation. Now, the extent to which that factor weighs or is considered in a specific case is going to vary from case to case, from judge to judge. There are some states that have done exceptionally well, I mean, depending on which side of the fence you're sitting on, with actually making domestic violence a huge factor. It has significant weight. If there's a presence of domestic violence and the court is convinced that it happened, and the court is convinced that it should be, it meets the criteria for the best interest of the child factors component of your case, your custody case, then the judge can decide whether or not, not just custody, but whether or not visitation should be based on the presence or the existence or the finding of domestic violence. Now, there's several things that come up when we actually consider what the judge considers a proven case and whether or not that proven case meets the criteria of DV. And I'm going to use California for an example, because California has a rebuttable presumption when it comes to DV and the best interest of the child factors. What California does is it says when there's a presence of DV in the case, and when I say presence, I don't mean just an allegation. Judges are way more advanced than that. There needs to be more than allegations. It needs to be proven. There needs to be a finding that there is DV that exists between the parties. The California law says that there is a rebuttable presumption that when there's a proven case of DV that existed between the parents or in a custody case, that the parent, that what that means is that the rebuttable presumption means that the court is going to start from a position that the parent who has actually been the abuser is not fit to have custody or even joint custody. That's the starting point. They're going to assume that they're unfit because they've been found guilty or it's been proven that they are an abuser. And the burden is put on that party to prove to the court that it is either not guilty or it's not been proven that there has been domestic violence, and or that because of that they are not unfit to have custody or to have joint custody. Now, California is the only state that makes domestic violence a rebuttable presumption, and California did well in that respect, because instead of what most states courts do is make it a discretionary factor, or and when I say discretionary, I don't mean in its whether it applies. They make it discretionary in how it applies, in the weight or the consideration they give it, in even what they will allow the accused, the alleged victim, to prove that there was abuse in the case. A lot of states have a lot of latitude, a lot of discretion when it comes to that, and so because of that, they really fail. They fail. Yes, they fail in actually giving DV that much thought or that much consideration or that much weight when it comes to making a custody or visitation consideration. And it's no secret that the courts are not really that well versed in applying or taking seriously domestic violence accusations or allegations, or even, even in cases where the accused has been convicted of some sort of domestic violence, there's still some judges who will overlook that. I hear stories every single day of people who have presented cases of abuse, and the judge agreed that there was abuse and still decided that the other party gets custody or even joint custody. And I'm talking physical custody. I'm not talking about legal custody. I'm talking physical custody, 50-50. So California is different. It makes it a little bit more complicated, a little harder for an abuser, a confirmed abuser, to actually get joint custody or 50-50 custody, or even custody, sometimes even visitation, actually. Sometimes they'll award supervised visits, therapeutic visits, any other deviation from the standard physical access, physical parenting time. So yay, California. The same with coercive control. In the state of California, the courts actually have, I believe California is one of the 10 states that has coercive control as a crime. I believe. I need to verify my sources. But in the states that, I'm just checking. Yes, California. It's Picky's Law in California. It's Caden's Law in Colorado, Grayson's Law in Florida, Kara's Law in New York, Abriel's Law in Tennessee, and Ohm's Law in Utah. Those are all the coercive control legislation that has been passed in the last, maybe, I think the last 7 or 8 years, I think, maybe longer. But yes, California is certainly one of them. The thing is, though, that how each court defines coercive control is going to vary. How each court applies the coercive control penal law is going to vary. What the consequences are, the statute of limitations for them are, it all varies. And because of that, it makes convictions of coercive control in criminal court that much more complex, let alone its applicability in family court, right? Because those are two separate things. Coercive control laws on the books are only on the books for criminal law. There are some states, like I believe Connecticut, that actually adopted coercive control as a component of DV pursuant to the custody or pursuant to the best interest of the child factors. So that actually makes it an element, makes it a specified requirement criteria for DV in Connecticut. Not all states have done that, though. They haven't all done that. So even though a state might have adopted legislation and to make it a crime, to add a coercive control as a crime to its DV laws, that doesn't necessarily mean that it's going to be applied straight away in family court. And even though, yes, I know what I said, even though every single state has, as one of its factors, the presence or the existence or the, proven circumstance of domestic violence haven't existed, haven't occurred in a custody situation, it doesn't necessarily mean the judge is going to actually rule accordingly or rule in the way that you would think. And that's where I had to let my audience down, where there was so many people who were really excited about the fact that it was even the laws were starting, more states were actually adopting laws or passing legislation where they made coercive control crime. Because making it a crime and expanding it, the DV laws to include the coercive control, does not automatically make it applicable in family court, because of what I just said. There's so many variables. There's absolutely some. I mean, we can't even get a judge sometimes to rule that one party, specifically the abuser, we can't even get a judge to rule that an abuser, that is not an accused abuser, a proven abuser, even repeated abusers, we can't even get a judge to automatically disqualify them from custody, making them unfit or denying them access. We can't even get, it's not an automatic. It's not a given. We can't even get judges to say, you know what, since you're a repeated abuser, a proven repeated abuser, you have convictions here for abuse, not just one, a few. You know what, you're still not unfit. We're still going to allow you to have custody or 50-50 or even access, unsupervised access. And unfortunately, that has led to actual deaths of children in the past couple of years, right? So the same thing with coercive control. It expands the umbrella, but it doesn't necessarily mean that the umbrella is going to be that effective, right? It doesn't necessarily mean that you won't get wet, for lack of a better analogy. So what it did is it gave the courts, or it gave the lawyers anyway, or the pro se litigant, more ammunition to make an argument that, because coercive control existed or happened or, was an issue, is an issue, that the judge should actually take into consideration that specific portion of your case when it comes to making that decision as far as custody is concerned. But it doesn't make it an automatic. It's not an automatic. It's just not. Family court is way too discretionary. There's way too much latitude, too much freedom, not enough oversight, too many inconsistencies. It doesn't work that way, unfortunately. And so that's the real of coercive control. So yes, I am for, those advocates out there doing the hard work, doing the necessary work. I am I'm impressed by the people who are always on the front lines, really trying to affect change when it comes to DV. But at the same token, I hate to be that, bee buster. I don't want to say the word. But, when it comes to getting a judge to actually coming on board and doing, what is fair or just or in alignment with the child's well-being, physically, mentally, emotionally, spiritually, developmentally, that's an entirely different, different baby. That's entirely different. Judges are not going to say, hey, yes, we have another element. We have another, another whatever you want to call it, that fits under the DV. So now we could actually take some of these cases that we couldn't fit it in under anything. We had a hard time actually conceptualizing what the parents was describing for us, and now we've coined a term. We now have a legitimate term, and now it's actually been made into legislation, whether it be criminal and or family court or civil. It doesn't necessarily mean anything when it comes to application. That's always what's going to get you. When it comes to application of any law, of any rule, of any principle, that's the glitch right there when it comes to the judges applying it. And I've had this conversation with a few mental health professionals in the last few weeks, because they're always coming to me with these ideas and, ways to get the judge to, ways to get the parties, I'm sorry, to, better co-parent, to, use other alternative means of resolving disputes, or to address some of the, concerns about coercive control or any other sort of non-physical manipulation. And I say, hey, I commend you. But if you think that those methods or those processes are going to be automatically picked up and acknowledged by the judge, and serve as an impetus for the judge to actually do something, that something meaning exactly what the litigants want, specifically the survivor, that's an entirely different baby. That's an entirely different baby. There's no way. There's no way. The only way you'll know if your judge is actually going to do anything, when you're presenting evidence and proof that there's been coercive control, is to actually know your judge, is to get to know who your judge is and what their position is. My guess is, though, right now, is that a lot of them are not necessarily jumping on board. And I was talking to a divorce coach the other day, and we were talking about, a coalition. I'm a part of a domestic violence coalition now. And she was talking about the initiatives that she's working on, that we as a group will be working on for the next year. And I love her mission. I love the mission of the organization, and I love the initiatives. But in my mind, all I'm thinking about is, is the judge's perspective, and I said to her, I'm like, you have to, somewhere in there, you're going to have to figure out a way to bridge the gap between, because informing the judges is not the problem. Some judges are required to take DV trainings. Most judges, I would have guessed by now, have to take some sort of DV training. Right? Judges have to do continuing education, just like lawyers and doctors and therapists and so on and so forth. And so a lot of them have to do DV training. So it's not that. They're knowledgeable. And some, of course, are more knowledgeable than others for whatever reason, personal reasons, beliefs, values, whatever. Culmination of all of those. But when it gets to the point where you're expecting the judge to actually do something when they're on the bench, and they're presented with facts that are, raising questions of coercive control or any emotional abuse or psychological abuse, that's a whole nother feat. That's a whole nother endeavor that you, especially as a pro se litigant, will have to endure, will have to face. And how do you do that? There is no one easy answer to that. There is none. But I do know that is not, just like there's no one size fits all when it comes to cases in family court, there is no one size fits all when it comes to application of the law or application of the procedural rules, or how the judge actually interprets whatever it is you're presenting to them. So if that is your position right now, if you're, the survivor of, years or, months of coercive control, and you believe that it's having an impact on your child's well-being, physical, mental, emotional, spiritual, or developmental well-being, then that's your job. That's your job to figure out how you're going to convince the court to actually, number one, believe that it's happened. Number two, make it fit into the best interest of the child. And number three, make the judge or convince the judge that because of those, the 50-50 should be off the table. Sole physical to that abuser or that accused should be off the table, and or maybe even some sort of supervised visits or therapeutic visits, or any sort of rehabilitative measures that can be put in place to sort of address those concerns. So, sorry, I hate to be the bearer of not so good news. I don't want to say bad news, but not so good news. But yeah, I wouldn't get, excited. I wouldn't be too excited about thinking I have this, airtight, you know, really rock solid case of emotional abuse or coercive control, thinking that the judge is going to do the right thing and decide to rule in your favor as a survivor, because, coercive control automatically makes the other party, the other parent, unfit. I wouldn't do that. I would actually tailor my case based on, several factors, several specific components, the elements, and I that's exactly how I'd present my case to the judge. So that is all I have for you today. If you have any specific topics you'd like me to discuss specifically about DV, please do not hesitate to email me at divorcecoachesq@gmail.com. That's divorcecoachesq@gmail.com. And I will try to fit your topic in. We only have a couple more weeks in the month of October, so there's only a couple more episodes that I will devote to domestic violence in honor of Domestic Violence Awareness Month. So if you could get that in yes, we have 2 more weeks. If you could get that in sometime before the end of the month, specifically October 28th, I would definitely try to squeeze that in. Next week, I will choose another topic that is really important, that is really relevant, that's really widely discussed and prevalent within the family court community, and specifically related to domestic violence. And I will take the time to go into depth about something. I like to choose topics that are often misunderstood, that is misled, that is that might be myths. So if it's a topic, regarding that, because I like to pick it apart so that you understand from a strategic standpoint what you might be able to do to reach your goal, to accomplish your goal. So that is it. That's all I have for this week. Thank you so much for tuning in. Until next week, take care. I want to thank you for joining us here at Self-Representing in Family Court, where we discuss all things strategy in family court. Join us next time. Until then, visit us at www.thedivorcesolutionist.com.